As we conclude our exploration of Arizona's timeshare laws, it is essential to address one of the most sensitive and highly regulated aspects of the development and sales process: the acceptance of deposits or reservations before the issuance of a public report. This rule embodies the state's commitment to protecting consumers from premature or misleading sales activity. Even before a developer is authorized to sell timeshare interests to the public, Arizona law recognizes that marketing efforts may begin early. However, these activities must occur under strict conditions established to ensure no funds are mishandled and no consumer is misled about their rights. The public report, as previously discussed, is the cornerstone disclosure document that provides prospective purchasers with critical information about the timeshare project, such as ownership rights, developer obligations, and financial details. Until this report is reviewed and approved by the Arizona Department of Real Estate, ADRE, no binding sales contracts can be executed. However, developers are allowed to take pre-sale deposits or reservations for timeshare interests under specific, tightly controlled circumstances. Under ARS, PGRA 32-2197.R10B. 8. A developer may accept earnest money or reservation deposits prior to the issuance of a public report, but only if certain statutory conditions are met. First, all funds collected must be placed into a neutral escrow account with an independent escrow company, title company, or financial institution authorized to do business in Arizona. This requirement prevents the developer from accessing or using the money for construction, marketing, or operations before ADRE has formally approved the project for sale. The law also mandates that these funds remain in escrow until one of two events occurs. The public report is issued, and the purchaser signs a formal purchase contract acknowledging receipt of the report. Or, if the department denies an application for a public report on a timeshare plan on which timeshare interest reservations were taken, within 5 business days after notification by the department, the prospective seller shall notify in writing each prospective buyer who entered into a timeshare interest reservation agreement. The prospective seller shall return any reservation deposits previously taken. The second condition ensures that no consumer funds are held indefinitely, while the developer delays obtaining ADRE approval. If the 180-day period expires without issuance of the public report, the escrow agent must automatically refund the deposit to the purchaser without penalty or deduction. In practice, the deposit must be accompanied by a written reservation agreement. According to ARS, paragraph 32 to 2197.08b, this agreement must clearly and conspicuously state that the buyer is not purchasing a timeshare interest at that stage, and that their reservation does not bind them to complete a future transaction. It must also inform the purchaser of their unconditional right to cancel the reservation at any time prior to entering into a purchase contract and to receive a full refund. This disclosure protects consumers from high-pressure or misleading sales tactics during the early marketing phase. For example, consider a developer promoting a new timeshare resort in Pinetop before construction begins. The developer hosts an informational event and invites attendees to place $1,000 deposits to reserve an ownership week once sales open. Under Arizona law, that money must be held in an independent escrow account, and each reservation agreement must include the statutory disclaimer language. If ADRE has not issued the public report, or if the purchaser changes their mind after 2 weeks, the escrow agent must return the deposit in full. Developers who fail to comply with these safeguards face serious legal consequences. The premature collection or use of funds without proper escrow handling or disclosure constitutes unlicensed or unlawful sales activity. Here is an example. A developer began accepting deposits for timeshare interests before receiving its public report approval and failed to hold the funds in escrow. The court would uphold ADRE's enforcement action, resulting in substantial fines, restitution orders, and suspension of the developer's authorization to market the project. the department's strict zero-tolerance stance on premature sales activity and would investigate and hold a public hearing. It is also important to understand the consumer rights implications of these rules. Because the reservation agreement does not constitute a binding sale, the buyer retains complete control. They may rescind at any time without explanation and without forfeiture of funds. Furthermore, even after the public report is issued and a formal purchase contract is signed, the buyer retains the statutory 10-day rescission right under ARS, paragraph 32, 121997.03, as previously discussed. Together, these provisions ensure that buyers have multiple layers of protection before, during, and after contract execution. Arizona's system contrasts with some other jurisdictions, where developers can solicit soft reservations without clear escrow or refund requirements. By requiring developers to use third-party escrow accounts, the Arizona legislature has effectively eliminated the risk of misappropriation of pre-sale funds, a problem that plagued the industry in other states during the 1980s and led to widespread consumer losses. From a real estate licensee's perspective, assisting a developer in promoting or collecting reservations prior to public report approval is only lawful if all statutory safeguards are followed. Licensees must ensure that no representations are made suggesting that a sale or transfer of interest has occurred, and they must verify that all promotional materials include the disclaimer that no sale may occur prior to the issuance of a public report. Violations can expose the licensee to discipline under ARS, paragraph 32, 153, for dishonest or untruthful advertising. Review summary. Arizona law allows developers to accept deposits for timeshare reservations before the public report is issued, but only under strict regulatory conditions outlined in ARS. Paragraph 32, 21997.02. All deposits must be held in a neutral escrow account. Purchasers must be fully informed that no sale has occurred, and refunds must be immediately available upon cancellation or expiration of the 180-day period. The law ensures that no funds are used for project costs until ADRI approves the public report, protecting consumers from financial loss and false marketing. Non-compliance can result in license suspension, fines, and mandatory restitution. Discussion prompts. Why does Arizona require that reservation deposits be held in an independent escrow account? Answer. To prevent misuse of consumer funds before the project is approved and to protect buyers from financial loss. What must a reservation agreement disclose to be compliant under Arizona law? Answer. That no sale has occurred, the purchaser may cancel anytime, and all funds will be refunded if the public report is not approved. What enforcement actions can ADRI take if a developer accepts deposits without an approved public report or escrow? Answer. ADRA may impose fines, order restitution, suspend the developer's sales authorization, or refer the case for civil prosecution. Closing remarks. This final section reinforces the overarching principle of Arizona's timeshare regulations: consumer protection through transparency, fairness, and accountability. The pre-sale deposit rules exemplify how state law balances the developer's need to gauge interest in a project with the purchaser's right to safety and informed consent. Real estate professionals who understand these rules not only ensure legal compliance, but also uphold the trust that is essential in Arizona's real estate market. The integrity of the industry depends on these safeguards being respected at every step, from pre-sale marketing to closing and beyond.